Good evening, good afternoon, and good morning to everybody. My name is Mohamed Raouf. I'm the chairman of the Egypt branch of the Chartered Institute of Arbitrators, which is organizing today's webinar in cooperation with the Cairo Regional Center for International Commercial Arbitration. The Egypt branch of the CIArb was established in 1999. It holds a wide range of events, including training programs, seminars, courses, including what we call at our branch the Wednesday 1 seminar. Today is one of our seminars. For reasons that you all know, it's now a webinar. And we have very recently launched a mentoring program for the young practitioners in our part of the world. If anyone is interested in learning more about the branch, its activities, I invite you to get in touch with us in order to join and participate in our events and activities. Our webinar today is titled Investment Treaty Reform in Times of COVID-19, a Policy Perspective. The topic is very timely, as you all know, due to the challenging COVID-19 moments that we are all facing nowadays, and which of course does not come without legal ramifications. I note in this respect, for instance, just to give you an idea about the importance of the topic, that it was announced very recently that a Latin American state has been threatened with an exit case filed or to be filed by a European investor arising out of an airport concession due to measures taken by the host state in response to the COVID-19 pandemic. I'm therefore delighted to introduce our guest speaker today, Mr. Mohamed El-Kady, in order to address the topic and any questions, relevant ones that you would like to put to him, with respect, of course, to our topic today. Allow me first of all to introduce to you Mr. Mohamed El-Kady. Mohamed is an investment policy advisor in UNCTAD. He has been working in UNCTAD's division on investment and enterprise since 2002. He is also part of the team drafting the World Investment Report and has authored a number of UNCTAD series on international investment policies for development. He provides technical assistance to government officials. Among such government officials, I believe we have some participants today, and policymakers on issues related to international investment policies. He has also coordinated the implementation of over 50 international, regional, and national seminars, workshops, and conferences on investment issues worldwide. Was very pleased to be among those who accompanied Mohamed in different venues all over the world, including Cape Verde some years ago. He has also published various articles on international trade and investment policies and their development implications, in addition to being a frequent panelist at international conferences on investment policies and lecturer for various academic institutions. Mohamed, welcome to you, and I'm really grateful for you to have accepted to talk to us today among the activities of our branch. And in agreement with Mohamed, we have decided to organize today's webinar as follows. I'll be putting to Mohamed 4 questions for him to address. After addressing such questions, we will be reverting to you, to our audience, to our participants, by raising 4 questions, and we will be kindly asking you to select one answer among the answers provided to you. It's a kind of a survey for us to assess. Mr. Mohamed El-Kady will be assessing the outcome after addressing the questions that I'll be putting to him. And we will be concluding this webinar by a Q&A session based on questions that I invite you to put in writing for us to select the most relevant ones and kindly ask Mr. El-Kady to address them. Without any further ado, I give the floor to Mohamed to give a short word, if he wishes, before I put the questions to him.
Thank you very much, Dr. Abdel Raouf. It's really a great honor and pleasure to be with all of you today. I, in the beginning, just wish to thank very much the Chartered Institute of Arbitrator, the Egypt branch, for the excellent work you have been doing. We have been following closely the work you have been doing, so congratulations for that, and thank you very much for the invitations. Thank you also to the Cairo Regional Center for International Commercial Arbitration, which has been a long-standing partner of UNCTAD. So I'm very happy to be with you today.
Thank you very much, Mohamed. And now, if you don't mind, let's start by asking you to kindly address the first question. Why, in your view, Mohamed, international investment agreements reform is important now in such challenging COVID-19 times?
Thank you very much, Doctor. I think this is a crucial question and very important, very timely, and very good question to start the discussions today. I think IIA reform, or the reform of the international investment treaty regime, has always been important. But we are seeing now today with the COVID-19 pandemic that the importance has shifted now to, it has become now an urgent need to reform the existing investment treaties. It's important to recall that the overwhelming majority of the international investment agreements, there are close to 3,000 today, the overwhelming majority has been concluded 30, 40 years ago, the bulk of the network. So in UNCTAD, we call for the reform of these treaties with a view to find a balance between the need to maintain adequate levels of investment protection on the one hand, and on the other hand, what we believe was missing and is still missing, the right of the state to regulate, and the inclusion of provisions relating to the emerging problems, global problems that we are facing today, such as climate change, of course now health, and the generally the sustainable development goals. So the importance of reforming has gained momentum today in the COVID-19 pandemic, precisely because we are seeing that countries, of course, have taken various measures, either to mitigate the economic impact of the crisis or to protect public health. These two parallel measures were taken in most countries of the world. Measures taken for the protection of public health, for example, could include the mandatory production of certain items, medical items or hand gel or masks, export bans, for example, on certain products that are important in times of health crisis. Some countries have taken over hotels for temporary period of time to turn them into a place where COVID positive people could stay there, or even temporary hotels that could very well be owned by foreign investors. On the other hand, and in parallel to these measures, countries have tried to revive their economies, to inject funds and support to foreign investors and domestic investors through financial support, fiscal support, tax holidays, diminishing the costs of electricity and so forth. So countries have tried to do these two measures simultaneously. Now we see that unfortunately these two measures can come, and as you mentioned in the beginning, there are already threats. These measures can come into friction with international investment agreements that were mostly concluded in the 80s and 90s. So you can imagine the frustration of governments that are trying to protect public health, to revive the economy, and being threatened by sometimes very expensive investor-state disputes based on treaties signed maybe in 1972. So from that point, reform of the treaties are urgent. May I add another example that we also found recently there are two examples, one in Peru and one in Chile. The first one relates to an investment in a highway, which the government had suspended the collection of tolls in response to the pandemic. And in Chile, the two French operators have threatened to bring a claim against the country for closing airport routes and imposing sanitary measures. So from that point, that's why the reform of investment treaties are extremely important today. We are trying to find a balance, trying to find treaties that result in a win-win situation and not only focused on one aspect, which is investment protection.
Thank you very much, Hamid. Now that you have pleaded the case of the urgency of the reform, allow us to learn more and know what are the most urgent treaty provisions that you believe are in need of reform and how.
Yes. Ideally, reform should be gradual but comprehensive, which means that all provisions included in international investment treaties are in need of reform. But of course, some provisions are more in urgent need of reform, or are more pressing. Reform needs are more pressing. And that's because we see, and we have made this research in UNCTAD, that there are provisions that are, of course, much more frequently invoked in ISDS claims. And we found, for example, that in over 80% of all ISDS claims, fair and equitable treatment, for example, is regularly invoked, precisely because of its broad nature, its catch-all nature, and how it is drafted. So even if the disputes relate maybe to a national treatment measure, foreign investors will always, or most of the time, also include a violation of fair and equitable treatment because of its very broad nature. It's very difficult to capture the essence of what this provision really entails. So in UNCTAD, we have developed very recently, actually last month, the IIA Reform Accelerator, the International Investment Agreements Reform Accelerator, which takes a step forward in terms of not only providing abstract policy recommendations, not only providing what countries can do and should do, but actually looking at specific language and specific treaty examples from existing models, model bilateral investment treaties or regional investment agreements or bilateral investment treaties. We take these examples and we put them in a user-friendly manner for countries, government officials, policymakers that really want to actively engage in IIA reform. If we can, to answer your question, I think one of the very important provisions, I believe personally, is the definition of investment. The definition of investment is extremely important because it tells you what you are protecting. And if you know what you are protecting, you would be willing as a government to then give the protections that you want to give. The worst case scenario is protecting something you do not want to protect or you did not intend to protect. So the definition of investment should be as much as possible limited. And here I know that limitation or maybe has a negative connotation, but in the context of today in 2021, limitations, clarifications, refinements, and more targeting approach to these provisions is what we call the new generation of investment treaties. So trying to define the investment in a way that covers only the kinds of investment that the country sees as contributing to its national economic development strategies, instead of just defining it as any kind of asset. I think these kinds of definitions now belong to the old generation of treaties, and we are seeing that the new treaties are shifting away from this very broad asset-based definition of investment. Then we have the fair and equitable treatment, of course, the expropriation provision, specifically the indirect expropriation provision. Most favored nation provision is also extremely important, together with national treatment. The public policy exception is gaining a lot of importance now because of the possibility to protect public health under such exceptions, and of course the ISDS mechanism. So these are the provisions that we think are important. There are other provisions, of course, that are important, like the transfer of funds provision, for example, but our new document, the Accelerator, looks at these provisions as a first step, and we are planning to do a second version of the Accelerator, looking at the rest of the provisions in this year. Yeah. Thank you.
Thank you very much. I assume that among the provisions that you have identified or definitions that you have identified is also the definition of what is an investor. This is also.
Yes, of course. This is also, I forgot about this one. This is of crucial importance. You need countries ideally want to know precisely, clearly, who they are protecting and what they are protecting. And once this is clear in the mind of everyone and clarity comes through precise drafting, then of course the picture is more predictable for both the investor and the state.
Thank you, Ham. And I note that you have kindly provided us with a link to the UNCTAD's new IIA Reform Accelerator that has been sent to our registered participants by our friends at Corsica. And would you like to shed some more light about how should we go through such accelerator, or this would be covered under the third question?
I think the third question mentioned was
how is
yeah,
stepping up its assistance?
Maybe I think that's a good point. Maybe very quickly sharing with participants how the accelerator works and how do we propose reforming these provisions. So of course, the accelerator starts by analyzing the situation today, calling for the reform, for moving to a new generation of investment treaties, then provides the solutions how to do that and providing specific examples. So for example, just selective examples, the definition of investment we already talked about, but we call for a more refined definition of investment that maybe lists specific characteristics of an investment. By the way, every investment, one of the main characteristics of an investment is risk. And people don't want to hear much about that if you are on the investor side, of course, because no one wants to lose money. But risk is characteristics of an investment. And so there is always a possibility of losing money. And losing money is it's part of the rules of any kinds of investment, if you want. And COVID-19 is, I think, unfortunate, but it is a risk, and it is something that governments did not do on purpose. It's an act of nature or God or force majeure. And so you have the fair and equitable treatment as well, which we call for a clarification of what it entails, either by including a specific list of state obligations that these obligations are fair and equitable treatment, or linking fair and equitable treatment to customary international law or the standard of the minimum standard of treatment as well. So there are various options, and we don't say in the report that this option is the perfect one, because there is no one size fits all. So governments will pick and choose, but what they have in common, our reform approach, is that they all belong to, they all aim at restoring a certain balance, maintaining investment protection, which again is extremely important. And reform does not mean less investment protection. This is very important to clarify, that more refined standards and more precision and more clarification does not mean less investment protection. It simply means clarity for my rights and my obligations for both the state and the investor. And I think that would also be reflected in future ISDS claims, where arbitrators will also know much quicker. There will be less room for very creative interpretations and resulting in contradictory or contradictory or decisions that might be surprising one after the other based on the same measure, for example. Inconsistency. ISDS mechanism, we also elaborate or explore the use of dispute prevention mechanism. We emphasize also that there are other options to ISDS, like state-state dispute mechanism or local dispute resolution. We also put examples from IIAs that include a permanent court system proposal instead of traditional ISDS. And expropriation, for example, I think we have many examples of how to limit the expropriation provisions by clarifying that indirect expropriation should not include measures taken for the protection of certain legitimate policy objectives, for example. So I think it's a useful document, especially for government officials and negotiators of investment treaties. And if participants are interested, I ask you can have a look at the report, and there is a contact us link if then you have any kind of questions or need clarifications.
Thank you very much, Hamid. And now I understand why accelerator. So it would encourage policymakers to accelerate the reform. So let's move to the third question, Hamid, and this relates to your institution, the UNCTAD. How would the UNCTAD step up its assistance in order to develop, for developing countries in particular, in order to reform their investment treaty regimes?
Yes, of course, this last year has disrupted the way, like everyone else, the way we are doing business. Technical assistance has been affected. UNCTAD has three pillars when it comes to investment treaty work. Just very simply, one pillar is research and policy analysis, which, for example, the accelerator or other reports that we write on this issue, which have policy recommendations. The second pillar is intergovernmental consensus building, when we bring together governments, developing economies in transition to discuss issues related to international investment agreements, to exchange point of views. Our meetings are also inclusive. We had a very big conference in November held virtually, where we had panelists from the private sector, from civil society, from academia, governments, of course, but also international and regional organizations. And the third pillar of our work on investment policies or investment treaties is technical assistance and capacity building. So what we need to do, and what we have started doing, is to adapt to the changing circumstances and to step up our virtual technical assistance and capacity building. It's much cheaper, of course, so there is a cost effectiveness, but of course there is a lack of personal contact, trust when you meet someone, you talk to the person, and that builds long-term relationships and long-term friendships, and that is missing. However, in terms of substance, I think our messages come across okay with the virtual means. We will step up our technical assistance and capacity building through these webinars, and we have a series now of webinars, either for specific regions or for individual countries. This in addition to our research and policy analysis. Of course, just to give you an example, last month we have been working closely with Egypt on its new model bilateral investment treaty. We have been working in close consultation with Gafi and with the Ministry of Investment, now only Gafi, and we have continued our support for many years, and we continue hopefully towards the adoption of a new Egyptian model investment treaty. We are also very active at the African continental level with the investment protocol of the African continental FTA, which is scheduled to be negotiated very soon.
Thank you very much, Hamid. And I was about to ask you to give us some examples. You have referred us to a local one, local meaning in Egypt, the country to which we both belong, and also an African one, a regional one. How does this work, Hamid? Do you knock the door or countries come to you? How does it work?
That's
you raise awareness.
Yes, thank you. That's an excellent question. Because as you know, Doctor, it's everything we do is for free. For free meaning we don't ask for funds to write a report or to analyze a bit network. Even if treaties, a country can have 100 treaties and we have to analyze all the treaties and write a report on that. Our technical assistance and capacity building is for free, of course. I mean free every country has to pay a part of the budget to the UN, but I mean, there is no extra cost to do that. So we have many requests, and we do them as one after the other. A request comes through an official letter from the ministry, for example, requesting UNCTAD to conduct either an investment treaty review or an FTA review, or they want to have a new model BIT. And based on the letter, we see how we can help them, either by a report or by a face-to-face workshop. And we discuss then with them the modalities of what they want to achieve.
Thank you very much, Hamid. If you don't mind, let's move to the fourth question that I want to put to you. To be more concrete and to end your presentation with concrete recommendations, Hamid, what are the main recommendations for countries that wish to maintain a strong legal framework for investment, while at the same time ensuring the right to regulate for public interest? Concretely, what can you recommend?
Okay, I think concretely the most important thing is not to be worried about reform and to engage in reform. Concretely, that means establishing, for example, an inter-ministerial task force. We often see countries, developed and developing, working in a vacuum. You have a small team maybe working on the national investment law. You have another ministry with a small team working on free trade agreements, which also can have an investment chapter. And these two do not necessarily consult with each other or don't consult enough. Then you have a third team or a third ministry working on bilateral investment treaties. And then you may have the investment promotion agency that deals with providing incentives, providing all sorts of marketing for the country, investment promotion and facilitation measures. And working in a vacuum results often in contradiction in what countries have either at the national level, the investment law, the bilateral investment treaties, and the FTAs. You can have a very modern, excellent national investment law drafted in 2019 or 2020, but you maintain a network of, I don't know, 60 or 70 old generation bilateral investment treaties with very broad definitions and very broad protections. So obviously you dilute the importance of what you have done at the national level, because a foreign investor will simply choose to rely on the bilateral investment treaty, maybe signed in 1972 or 60 or 80 something. So concretely, it's to form these task force to look at all the obligations of a country relating to investment in a coherent manner, exchange information among ministries, have teams consulting with each other, whether the FTA team, in bilateral investment treaty team, and devising a coherent strategy for reforming the investment treaties. Countries cannot reform overnight. We understand that. There is a need to develop a model that will guide the negotiators. There is a need to know what the country wants to do with investment. What are my priorities when I'm attracting investment? What are the key sectors I want to attract investment in? And what do I want to achieve? And what do I want to achieve should be translated or into the international investment agreement. There is no need anymore for having 3,000 investment agreements that all look the same. The devil is in the detail, of course, but they all look the same. And you wonder, how can this treaty reflect any kind of specific development interests I have as a country? Maybe a country wants to create jobs as its main primary objective from investment. Others want to target IT companies. I mean, you have a variety of objectives and interests that you can achieve. We have this document that it's slightly old now. I keep referring to it as new, but it's already from 2015. It's the Investment Policy Framework for Sustainable Development. And this includes a recommendation for this kind of question, is how to maintain a legal framework, because legal framework is also what you have nationally. It's a whole package. And so how to maintain also harmony and consistency between your national laws and your investment treaties. But the starting point is to review the investment agreements, establish an interministerial task force, have a coherent vision of what you want to achieve, and start renegotiating these old investment treaties and replacing them with modern treaties that reflect what we all want to achieve today, which means a balance, which means reflecting sustainable development goals and objectives, ensuring that the state has the right to protect public health when it has to do so, while at the same time ensuring that investors still can make money, can make profit, can transfer their profits back home, and reach a win-win relationships. Thank you, Doctor.
Thank you very much, Mohamed. You mentioned, Mohamed, that states may be reluctant to reform. Why is that? You met many policymakers and you've been all over the world in order to discuss matters pertaining to international investment agreements. Why do you believe states are reluctant to reform?
This is an excellent question again, Dr. There are many, I've become an expert in why some countries want to reform and why others don't want to reform. I think, unfortunately, countries that quickly engage in reform, they have been already being, if I can say, bitten by a very strong ISDS case and very expensive award. Either it's the amount of the award that hurt, or the nature of the measure taken that really made a government official at the highest level aware of these investment agreements, aware that they are limiting our capacity to regulate. And so the first reason why countries are reluctant to regulate is because at the highest level of decision making, there is no either awareness or importance given to this issue. So you might have at the technical level, everyone is aware of the issues, everyone wants to reform, but it reaches a certain level in government where this is not a priority, or it's not the right, it's never the right time to reform. I have heard this so many times, not now. We have other important problems. A third reason to delay reform is to say that this will give the international community a negative signal to the business community. This will signal that we are taking a protectionist turn, and foreign investors will be scared and they will not come. There is a very big difference, I think, between reform and treaty termination or exiting the system completely. And this clarification is very important to make, is that reform does not mean no more international obligations. Reform means modernization. Reforms mean shifting from rules that govern investment drafted in the 60s and 70s to rules that respond to the realities of today and that respond to what governments want and what investors want as well, but in a new context, which is this balance. Yeah.
Thank you, Mohamed. And another question relating to the same point, Mohamed. Within the context of the interministerial task force that you have referred to, what should a public officer or a policymaker look at in order to assess the current legal investment framework? Should they focus on the case law relevant case law, should they have a comparative approach and compare the legal framework to other instruments in the region or elsewhere? What should they do?
I think they should start by reviewing the existing investment treaties and by order of, how do I put this, order of importance of the treaty partners. If you have a treaty with a very big developed country that has millions of dollars invested in your country, that has a history of having its investor using the investor state dispute settlement mechanism heavily and regularly, this would be a treaty that would be prioritized over maybe a treaty with a country that the levels of investment are near zero. And you wonder why they have a BIT, but they still do. That's because a lot of these treaties were signed a long time ago during a presidential visit. And you always see the president in front of the camera signing many different documents. I can assure you that in the 80s and 90s, one of the things he was signing was a double taxation treaty and a bilateral investment treaty, even if both countries have no FDI flows among themselves and very far geographically. And the case law is extremely important as well. So there's a need to analyze the substantive provisions in the investment treaties, to look at the case law, to identify which are the measures and which are the provisions most likely to create problems, and look at the FDI flows between the two countries in a matrix, and identify by level of priority. And that's sometimes we help the task force in doing that, giving a list of priority for renegotiations. This task force should also identify the time frame of these treaties. It's very important because, as you know, Doctor, a lot of these treaties, if you don't do anything about them, they will automatically renew themselves for extra 10, 15 years. So you need to be ready for the time frame when you are allowed to renegotiate or amend specific treaties. This task force ideally should also be looking at what you have at the national level, and to break this vacuum between, or this bubble between, international investment and free trade negotiators and those who are drafting national investment laws. There's very often a gap between these two type of government officials. The ones focused on domestic legislations on investment, and the ones focused on international negotiations. So this I think, enhancing the dialogue between the central bank as well should be included in this task force. I mean, one representative meeting maybe once a month. It's not a task force that costs money or time. This task force should be there, which is task force on reforming investment policies.
Understood. Thank you, Mohamed. And may I ask you, do you have an ideal profile for a policymaker who could engage in and initiate and accompany a valid reform? Do you have a profile for such policymaker from a background, a certain experience, macro level, micro level? What do you, based on your experience?
Yes, based on my experience, I think the best profile is not one profile. They will complement each other. Mm-hmm. If the profile is purely lawyer's profile, you will have hours of endless discussions on what this term mean, what that term mean, and where should we put this comma and where should we not put this comma. And at the end, you lose track of the bigger picture of what the country wants to achieve with investment. you might debate the definition of investment for hours or how to limit FET. So the perfect task force would have, of course, lawyers, because this is the key, but you also need someone who has a broader vision in terms of maybe the guys working on the how do you call this, National Development Strategy 2030. Every country has these big national development strategy or objectives that we want to achieve by 2040. You also need economists from the central bank, for example. They would be very valuable in the transfer of funds provisions and the balance of payments provisions. When should I include exceptions to the free transfer of funds and when not? Then also you might have someone from the Ministry of Foreign Affairs or someone who has experience in negotiating skills and interhuman discussion, negotiation skills. That would be the ideal negotiating team. If you have only the lawyers, it won't work. Only the economists, it won't work. And only the skilled negotiator, it also won't work. And that's what we see in a lot of these task force and negotiation teams from developed countries. They have 4 or 5 people. Every one of them has a different background.
Understood. Thank you very much, Mohamed. This is very for the interesting points that you have provided to us. If I have learned one interesting point, I'm not sure whether you agree with me. What I have understood from the points that you have addressed is that you are in favor of a quality protection of investment rather than increasing the number of investment treaties. We should focus on the quality of protection that is provided. Is that correct?
Yes, exactly. That's correct. And thank you very much for formulating it the way you did, because I often struggle to make a difference between reform and quality, as you put it, quality of protection. But what we are trying to do is modernize and shift from this very broad protection to a more refined protection and more modern protection. So that's exactly it. Quality protection is a very good term for that. And of course, also the right to regulate of governments is very important for us, of course, as the UN and as UNCTAD and member states are these are our member states, and they have every right to be able to regulate in the public interest in their territories.
Thank you very much, Mohamed. And before we conclude with the Q&A session, as agreed, if our friends at Corsica, Yahya, can share with us the 4 questions that have been prepared in order for us to assess what are the salient features of such reform. So let's start with the first question, and I'll leave it to Mohamed to put it to our audience, to our participants. Mohamed, if you may.
Yes, so just to clarify, these are questions that aim at making this discussion interactive, and it was an excellent idea from Dr. Abdel Raouf and colleagues. So the first question is, do you think countries should reform their old investment treaties, maybe signed in the 1990s or earlier? And reform can take different shapes. It can be amendments or joint interpretation or renegotiation or termination. So they should reform immediately. They should reform, but first they should prepare well. It's not the right time to reform now. There is no need to reform at all because investment treaties are fine as they are, or you don't know. So I will also, am I also allowed to answer?
Yes.
Okay. So I will answer.
Hopefully, and for the record, allow me to say that this idea was brought by Yahya, our friend from Corsica, and we all agreed that it is extremely relevant. So let's start by answering the first question and submit our answers and then see the outcome. Do we have a result, Yahya, or not yet? Until we receive his feedback, yes, I leave it to you, Mohamed, to assess.
Yes, so I hope I have the results in front of me. These are the right results. Is 10% said we should reform immediately. 88% said countries should reform, but they should first prepare well by having a review of their IAA network, develop a model and a negotiating strategy. So I think
no surprise here.
No surprise. Reform immediately. I can fully understand this point of view as well. Reform immediately, but of course it's better to prepare yourself first so that you know where you're going. If you have 50 or 100 bilateral investment treaty, you first need to review these treaties, develop a strategy, and have a model to guide you in the negotiations. But yes, no surprise, and I am happy with these answers. So
thank you, Mohamed. Should we move to the second question?
Yes.
Mohamed, would you like to?
Yes. Some old provisions in IIAs are more problematic than others. So which ones do you think are the most problematic? Of course, here from the point of view of the host state. So you have to put the shoes of a government official. I'm sorry if you are not, but it's a good experience. I will also put the shoes of a government official and will select some.
Of course, the sample, judging from the backgrounds of the registered participants, we don't have a sample that could give a reliable when it comes to host states, but at least an indication. Until we receive the results regarding the second question, Mohamed, I note, can you see the questions that we are receiving? We have more or less 8, okay, including one El-Kady.
Oh, so this is very interesting, and yes, I mean, no surprises here. 61% fair and equitable treatment. I think this is really the most problematic provision. As we mentioned before, I think the overwhelming majority of ISDS cases, investors claim a violation of fair and equitable treatment, even if the measure was maybe relating to the violation related to another provision. So it's a catch-all definition of investment. Maybe participants were influenced by what I mentioned, but that's also very, very good. And indirect expropriation, of course, and investor-state dispute settlement. So I think these are good answers. They're all important and they can all be problematic. But I think I think these are very good answers.
So as you mentioned, Hamid, gradual but comprehensive reform. So this really, the answers we got really reflect that.
Exactly, exactly.
Let's move to the third question, and thank you all for being interactive and for answering the questions of this poll. The third question, Hamid.
Which activities should international organizations, including UNCTAD, focus on and increase to assist countries in reforming their IIAs in times of COVID-19? Okay. Oh, we can only choose one. So now we have to choose the most important one. Okay. So
We're waiting for.
yeah. So Dr. Abdel, can I choose some of the questions because there are so many of them?
Of course, we have 8 so far, Hamid, including one from another El-Kady. So
yes, I will answer that question first because you know,
you have the
priority goes to. Okay, which activities should international organization focus on? And I have also answered the first one. There are other things are also extremely important. Many international organizations are working on all of these issues, but I think if we had to choose one, I would have chosen the first one, but the second one is equally important. So no surprises there. Yes, exactly. That reflects really what government officials have been telling us is they need something concrete. They need some reports, some policy recommendations, and no more big picture, blah, blah. They need specific recommendations.
concrete ones, absolutely.
Yeah.
Now, let's move to the last question.
Yeah. What should be the main recommendations for countries wishing to maintain a strong legal framework for investment while ensuring the right to regulate? So we can select up to 3.
Up to 3. We are about to have the final results regarding the last question, and we have them here. Hamid, if you want to make a quick assessment.
Yes, so 80% said that it's to establish a task force, interministerial consultations, and that's very important. And then develop policies and services for dispute prevention and mediation. That's also extremely important. And adopt national laws for the promotion of protection of investment, 38%. Of course, conclude new IIAs, it depends a lot on how this IIA will look like. If it belongs to the traditional or old generation of investment treaty, or does it belong to the what we call a new generation modern investment agreement that includes many different things and not only 12 pages on investment protection, then it could also contribute to a strong legal framework. So conclude new but better IIAs, I would have said. So very interesting results, and they all make a lot of sense.
Absolutely, and I'm particularly satisfied with dispute prevention and mediation coming or being ranked second. It's very extremely relevant, especially nowadays. Anyway, in order not to keep everybody for too much, I would leave it to Mohamed to select. We received 8 questions, Mohamed. Maybe
Yes.
one comment, but not really a question from.
Yes.
Would you like to
Yes.
select few ones and go ahead and address them?
Yes, I will start from the first ones, which is basically that reforming bilateral investment treaties is a challenging process because of the bargaining power, or if you are negotiating with a big developed country, then they will always impose their own views. So that's a good question, but that does not mean that countries should not start engaging in IIA reform. The first reason is that you can very well start renegotiating treaties with what we call like-minded groups. This divide between big developed countries having their own interests and provisions and smaller developing countries have a complete different view is going away now. There is a growing consensus or a growing agreement among the big developed countries, US, Canada, open any of the new FTAs of the European Union, for example, and you will see provisions on the right to regulate, you will see refinements, you will see limitation to access to ISDS. It's no longer a north-south issue. So this would be a very problematic, that's a real challenge if we were 20 years ago. Today, I think many countries are willing to discuss, to reform, and you would be surprised how many countries would actually have similar points of views on how to refine FET, how to define investment. What we need is the political will to go ahead and the awareness that reform does not mean less protection. Then, are you against I cannot answer this question. Are you for or against multilateral investment court? I think it's a good initiative, and it's not. I'm in no position to say if I'm for or against that. I think it is a very good multilateral process, a very good initiative, and any new ideas are always welcome.
Maybe a related question, Mohamed.
Yeah.
You are aware, of course, of the regional Arab investment court. Are you in a position to assess the development of this court and whether it has contributed to the development of international investment law?
Yeah, I think, I mean, I'm not in a position to say whether anything is good or bad, unfortunately. But what I can say is that any reform of ISDS at the multilateral level should not be cosmetic and should not be just solving one or two issues relating to legitimacy or this and that. A true reform of the ISDS should be, again, comprehensive. So you cannot reform ISDS without reforming the basis, the investment agreements. And number two, are countries going to be shielded, if you wish, from having to face ISDS when the measures they are taking are obviously, and I say obviously, for the protection of public health, public interests in general, whether it is a measure for climate. We have seen so many disputes for countries trying to achieve the SDGs, trying to shift to a cleaner and more sustainable future, having to face ISDS. Are these initiatives and reform will address these core issues, or are they only addressing one or two small cosmetic issue at the end of the day? The
final questions, Hamid.
Yes. I think the question about the EU approach from the EU is a good example of BIT reform. In your opinion, are there any other examples? Yes, of course. There are many good examples. And from the name, I suspect that is from Morocco. I'm not sure, but I have a strong feeling. And if that is the case, then Morocco is a very good example of a country that, in cooperation with UNCTAD, has, adopted a very good new generation model bilateral investment treaty, and has concluded one bilateral investment treaty with Nigeria. Actually, both negotiators met in one of UNCTAD's tech capacity building workshop. And this BIT includes innovative provisions, reform-oriented provisions on corporate social responsibility, on investment facilitation. You see a multitude of things that, in addition, of course, to investment protection. There are good examples everywhere. You look at RCEP. You compare the investment chapter of RCEP to a 1980 BIT. You will see a lot of innovations going towards the right to regulate, more refinements. You even look at the new NAFTA, and they can't agree how to call it, USMCA or Mexico first or Canada. I mean, the new NAFTA. You look at the new NAFTA, there's also a lot of very innovative reform-oriented provisions from, you see, the big developed countries. So there are a lot of examples around us. There's also the African continental FTA, the investment protocol, currently or imminently under negotiations, which I suspect will also include very important reform provisions. So reform is spreading, and the EU is one of the good examples, but there are many different examples, and I think I can. We have a database, if you are interested, that has all the most recent investment treaties, the full text,
including the one from Morocco. You have referred us. Okay.
The model is online, as well as the Morocco-Nigeria BIT.
Thank you, Han.
And apologies to the participant La Hussein if he or she is not from Morocco.
Understood. Would you like to take a final one, Hamid?
A final one, maybe from Christian Carvajal. He's mentioning something that we did not discuss today, actually, and something that I think the African Union has already, and if I'm not mistaken, the African Union has adopted a moratorium, a declaration on to suspend or on suspending investor-state disputes temporarily in times of COVID-19. So the question is, do you think that this suspension can be problematic? Who decides if the state, who decides if the measure is really related to COVID-19 or not? Well, the suspension is justified if the suspension is refined or limited or clarified. The suspension that is targeted is, targeting, for example, measures taken for the protection of lives or public health, clearly that would be justified. It's a temporary halt. But if this decision or declaration or moratorium does not specifically mention the kind of disputes that are to put on hold, then yes, it can become problematic. So this should be drafted carefully to ensure that they are putting a hold only on cases that are obviously arising from measures taken for the protection of public health. I would say even directly or indirectly for that matter, in a situation like this, where not only the investors are losing, we all have someone who lost something in the COVID-19. Some neighbors lost jobs, people lost lives, governments lost money. So this is unfortunate, but hopefully temporary. All this is temporary, and the things will get back better. And I think UNCTAD forecasts a very fragile pickup of FDI flows, maybe starting in 2022. 2021 will be a difficult year for FDI flows. Last year, 2020, we have seen a decline of, I think, 42% of FDI inflows worldwide. 2021, we will continue to see a decline, but a pickup can start hopefully soon after that in 2022. Thank you very much, Dr. Abdel.
Thank you very much, Mohamed. With this wishful and hopeful note, this brings us to the end of this webinar. As usual, Mohamed, it's been a real pleasure sharing this panel with you, albeit virtually, and hopefully soon we will be able to meet in person. I would like to thank you for your time and for the very informative webinar that you have given to us tonight. I would like also to thank our friends at Corsica for the technical support, and finally to all our participants. Forgive us if we have not addressed some of the questions that have been put to us, given the time limit that we have. And hopefully soon we will be in touch again, Mohamed, and try to see the outcome of the efforts that you are doing now in your institution, in our region, and worldwide. And before we conclude, I'm very happy to see the Egyptian cat, the black Egyptian cat behind you, which gives a very interesting Egyptian flavor to your international profile, Han. Thank you very much to everybody, and hopefully soon in person. Good night to all, and see you soon. Thank you.
Good night.
Bye-bye.
Thank you very much.